Thank you very much. That was a brief video about the Nigerian Center. Also, I also want to talk about our programs. We have different programs. Because is one, we're majorly known for our immigration program. So every Thursday we have a free walk-in immigration service. And it means you're able to come into the clinic, work, talk to the attorney, and it's for free. So every Thursday we're there from 12:30 p.m. to 4:30 p.m. at our address, 1231 Miriam Barry Avenue, Southeast DC. So if you need to talk to a lawyer on anything immigration, please, if you need help with naturalization, help with filling any of your immigration forms, they are more than happy to help you. So please make make use of the opportunity with the Nigerian Center, and you will receive the necessary help and adequate information you need. Also, we have a small business program where we help, build financial literacy and financial inclusion, and we help offer small business loans and credit building loans. So please visit our website. It's there. It's a very detailed website. All the programs we do are detailed on our website, so you can learn more about our small business on our website. We also offer other policy and advocacy programs, and we partner with other organizations to run different policy programs, which we put on our website. So please feel free to visit our website. They're very detailed, and you'll be informed about everything we do. We also have our home ownership program where we'll connect you to home counselors and all those that can help you, and those people that can help you finance your home, particularly first-time home buyers. So you can have access to lenders, and particularly the right kind of information and everything you need when you're trying to buy a home. So we equip you with the necessary knowledge and everything you need to know when buying a home. So please feel free to reach out to us, and we'll be more than happy to connect you with the home ownership counselor. Also, we have social services that we help out with, especially for DC residents and even non-DC residents. We're able to provide you the right information to go about, health insurance, ID card. For DC residents, we're able to direct you to the right offices to get your limited purpose ID cards and other things that will facilitate and improve, the quality of life, even living as an immigrant in the DMV. So please reach out to us if you need any of these services, and we'll be more than happy to help you. If you also visit our website, we have our language programs. We have the Igbo language, Hausa language, and Yoruba language programs start next week. So please, if you know anyone that is interested in learning these languages, please refer them to us, and we can assure you they will have a wonderful time with very, very knowledgeable facilitators. Also, we have our social media. We have very active social media pages. We're on Instagram, we're on LinkedIn. So please follow us on our social media platforms, and keep up with everything we do there on our social media platforms. All our upcoming events are also on our social media platforms. So please do also follow us on our social media platforms, and you'll be up to date with everything we're doing. We have the volunteer. Okay, we used to do this, the volunteer income tax assistance. Now the tax season is over, but if you know those that filed for extension and still need help with their taxes, please refer them to us. The IRS had given the opportunity for those that were not able to submit on the 15th to file for an extension. So if you know those who still need help and they're still within that grace period, please refer them to us, and we'll be more than happy to help them. We also have community partners. So we have different organizations that we partner with who do the same thing in our line of work. So if you're a member of the community, or somebody who is like a community leader that we can partner with and does work in the area of advocacy and social issues and impact issues, please let us know. I will be more than happy to collaborate and work together so that we can achieve, the greater good for the community. Okay, I've talked about our working immigration service, job readiness and employment resources for immigrants. Please check our website too for this, and you'll find all the necessary information. Also, all our programs on our website. Our media page would show you all our past programs. So please go there and click on the specific event and you'll be able to catch up on even our previous events. So get involved. How do you get involved? There are different ways to get involved. If you go on our website, we have different volunteer opportunities. So please reach out to us if you want to volunteer in any of these areas. And most importantly, I talked about our community partners. Another way to get involved is your donations. The Nigerian Center is a volunteer-led organization. So we rely on donations from kind individuals like you to move our work. So please, whatever you are able to donate, your $1, your $5 goes a long way. We're not asking for the big monies, just the $1, the $5, they make a huge difference in our work. And most importantly, we urge you to consider being a recurring donor so that, every month, if you have something designated to the Nigerian Center, it would also help move our work forward. And we look forward to your partnership in this area. So that's it. Thank you very much once again for joining. I'm going to hand you over to April Holloway, our darling attorney. Thank you, April, for joining us. And thank you for the sacrifice at 3:30 a.m. Thank you so very much. We appreciate you. Thank you, April. I will
No
stop sharing my
problem.
screen.
So I am going to be talking to you about the qualifications to win an asylum case, which is different from what is required to file for an asylum case. Then we're going to talk about protections for survivors of domestic violence. That's something that concerns men and women, not just women. And finally, what your rights are if you are put into removal proceedings. Those are immigration proceedings in the court. So let me first share my presentation with you. Just one moment. All right, and start from the beginning. Okay. Can I get a thumbs up, Mr. Emmanuel, only because you're the only face I see, if you can see this presentation that says qualifications for asylum? All right, thank you so much. Okay, so there are two, I'm moving too fast. I'm moving too fast for myself. Let me go back. Let me go back. Okay. Start from the beginning. Okay. All right, here we go. Now, there are two different ways that you can file for asylum. But first, let me explain the difference between applying for asylum and winning asylum. Anyone who has a fear of returning to their home country can apply for asylum. That is the baseline requirement if you have a fear of returning to your home country. However, if you're going to be successful in that asylum claim, meaning that the judge or the officer is going to grant that asylum application, there are some requirements you have to meet beyond simply having fear to return to your home country. There are two types of asylum applications. One is affirmative and one is defensive. Affirmative means that you are applying of your own volition. You have not been asked to appear in immigration court. You are applying directly with USCIS because you want to stay in the US, you want to seek asylum. Nobody's requiring you to do this. You're doing it on your own. Defensive asylum, on the other hand, is when you have been asked to appear in immigration court, and as a defense to removal, you are now applying for asylum. Okay, those are the differences in that application. Along with that, I want to explain what is withholding of removal and what is CAT. Protection under the Convention Against Torture is referred to as CAT because of Convention C against A, torture T, CAT. This has been in the news a lot recently because of the case of Kilmar Abrego Garcia, the man from Maryland who had a withholding of removal order and he still was sent to El Salvador. Withholding of removal is a lesser form of asylum. It says that You may remain in the United States because there is a threat to your life. However, there's some technical reason why you do not qualify for asylum. In most cases, that technical reason is because the person did not apply within the 1 year filing deadline, which makes them ineligible for asylum, but they are able to obtain withholding of removal. Are you still with me, Emmanuel? Okay, perfect. If I see somebody else's face, I'll pick on somebody else, okay? All right. So now we're going into the requirements. I just talked about the 1 year filing deadline. Mr. Kilmar Abrego, unfortunately, he missed that 1 year filing deadline. And so when he finally did get into court, the judge determined that he did not have a valid reason for failing to file within 1 year. So instead of giving him asylum, he could only get withholding of removal. Again, the difference there is that he's able to get a work permit, able to stay in the United States, but he's not eligible to apply for residency. Okay. When you get regular asylum, you become eligible to apply for residency, which is also referred to as a green card. But with withholding of removal, unfortunately, you are not eligible for moving on to apply for a green card. We're going to talk about some exceptions to the 1 year filing deadline in the very next slide, but let me go through the other requirements very quickly. You have to show that you've been persecuted in the past, that you have a fear, a reasonable, objective fear of being persecuted in the future. And number four is the most difficult one. You have to prove that the reason that you've been harmed in the past and the reason you would be harmed in the future is connected, is a nexus to a particular situation about yourself, your political beliefs, your religious beliefs, your sexuality, your gender, something personal and particular about you. It cannot be generalized crime or generalized civil war in the country. It has to be something that is particularly connected to you. And that's where a lot of people really struggle with that nexus issue. They can show something bad happened to me, and something bad might happen to me in the future, but they struggle with showing how is it particular to you and not the entirety of your country. Okay. The next thing you have to prove is that you are not able to internally relocate and be safe within your own country. And the last thing you have to prove is the government of your country is not willing or able to protect you. So we're going to go in more detail on those things now. But if you have any questions, you can type them in the chat. If I see them as we move along, I'll go ahead and answer them, and then I'll answer the other ones at the end if I can't fit it in. Exceptions to the 1 year filing deadline. So, if you experience either changed conditions or extraordinary circumstances, then you may be excused from failing to file within that 1 year. So, change conditions are things that materially affect your ability to apply for, or your eligibility, excuse me, not ability, eligibility for asylum. So, these can be personal events that occurred in your own country where when you first arrived in the US, you had every intent to return to your home country. But there's some personal event that occurred that now makes it where you cannot safely return, or something that occurred in the States that makes it impossible for you to return. An example of this would be a young person arrives in the United States at 19 years old, very young, green, they don't know themselves very well. And over the time that they've been in the United States on that student visa, well, now they have become more politically inclined. Now they have become more politically active. They've been speaking out against the government of their home country using their social media pages, and they have attracted the attention of that current government who has issued them the threat. If you return home and say these things and still believe these things, you will be put in jail and you will be tortured. Well, that's a changed condition from the time that they originally arrived in the United States on that student visa. So even if that happened 2 or 3 years down the road, well, they can be accepted from the 1 year filing deadline because that's a situation that did not exist when they arrived. Okay? With me? Let me see if we have any questions over here. Thank you, Mr. Emmanuel. And then we have extraordinary circumstances. Extraordinary circumstances are events or factors that directly impact your failure to apply within 1 year. These are always going to be personal events. So, for example, you arrive in the United States and it is your intention to apply for asylum immediately. You go and visit someone who says they're going to help you apply for asylum. And so that attorney takes all of your information, takes your I-94, and they say, yes, I'm going to apply your asylum application. You sign some forms and you think it's done. 3 years down the road, you find out that application was never submitted. Okay. That is an extraordinary circumstance. That is a legal disability that prevented your filing for asylum within the 1 year filing deadline. And if you're able to present that documentation showing, look, I hired this attorney, they said that they filed for me and they didn't file for me, you can be accepted from the 1 year filing deadline. Okay, let's do a example. Actually, I just gave you this example, so we're going to skip this one to a different one. All right, here we go. Now, X arrived in the United States from Cameroon with a visitor's visa. Several years after his arrival, his brother was murdered for practicing his religion. His lands were burned as well. X and his brother have the same religion. X will now apply for asylum. Does he have an excuse for his failure to file within the first year? Does he have an excuse for his failure to file within the first year? I didn't mean to move that, but feel free, unmute yourself and let me know. Do you think that he has an excuse for failure to file within that first year? Anybody? Let's see. I see something. I see someone in the chat. Let me see what this says. Oh, no. All right. We got one person who says, no, he does not have an excuse for failure to file within that first year. Anybody else care to take a guess? Oh my goodness. Okay. So actually, yes. So when X arrived in the United States, they did unfortunately violate their visitor's visa, but that can be overcome because several years down the road, there is a changed condition that presents itself. It is now dangerous for X to practice that religion in his home country. So if they are still practicing that religion as their brother was, as the statement says, they can now apply for asylum and say, I have experienced a changed condition in my home country. Okay. Will they be asked questions about their failure to depart after arrival on the visitor's visa? Yes. Can they overcome that? Yes. Okay. All right. So let's move on to the next element, which is past persecution. Look, I can see that I spelled persecution wrong. It's 4 a.m. Okay, just cut me a little slack. All right, past persecution is defined differently depending on which circuit you're in. If you're in Maryland, Virginia, DC, we are in the Fourth Circuit. The Fourth Circuit considers death threats, severe economic deprivation, rape, physical assaults, and detention as persecution. So if you are in a different circuit, obviously you want to look up exactly what is past persecution in that circuit. But if you suffer from these things in the Fourth Circuit, that is past persecution. How do you establish that you've suffered past persecution in the court or with USCIS if you're affirmatively filing? If you have photos of your injuries, if you have medical records, and listen, even if an injury is old, you can still go and have an exam here in the United States to establish what that past injury was. So, past or current medical records, therapist records, letters from friends, family, professors, community members, and background information. Listen, When you are applying for asylum, it is not the time to be um, private about the things that you've suffered, and it's not the time to minimize the things that you've suffered. I've dealt with many of people who've suffered violence that caused them to lose their hearing, caused them to have difficulty going out into crowds, but they don't share that information until it's almost too late. This is a process where you need to be able to sit with yourself and share upfront what you've suffered and how it's affected you if you want to have an opportunity to be successful with your asylum application. Can you choose your circuit? So the circuit is based on where you live. So to the extent that you are willing to live in different places, then yes, you can choose what circuit is being used to evaluate your asylum application. A lot of people want to live in Texas but have their case evaluated under Fourth Circuit or 11th Circuit law, but you have to live in that place in order for that to be valid. So, you need to move to New York or move to Maryland if you want to be judged by those standards. All right. Nexus. Now, this is the one that I said is the most difficult. Nexus means that the reason for the past persecution and the reason for the future persecution has to be connected to a protected grounds. Your protected grounds are religion, political opinion, race, which also includes ethnicity, tribal groups, and origin, protected social groups, gender, LGBTQ, membership, nationality. Another issue that I have when it comes to establishing protected grounds with um, specifically to ethnic origin and tribal group is that a lot of people distance themselves in some way from their ethnic origin, indigenous roots, tribal group. And it may be difficult sometimes, especially if you've been taught that you should be ashamed of whatever your ethnic origin is, um, to be able to talk about that. Again, when you're applying for asylum, it's not the time to um, be humble about those things. You have to be upfront with me as the attorney, so that I can understand the situation, especially if it's a place that I'm not so familiar with. The majority of my work so far has been with Spanish speaking clients because it's the language that I speak. And so if I have someone who is a Mayan indigenous person, I already understand some of the difficulties that come with that area. But if you're from an ethnic group that I'm not familiar with or that your attorney's not familiar with, then you have to take on the role of educating us in how you are treated in your home country because of that. And don't be shy about it because it is a grounds on which you can be afforded asylum. Okay. The other thing that happens sometimes is that people haven't quite worked out their identity. You might be in removal proceedings and you feel like you have some attraction to the same sex, or you feel like you want to dress in clothing of the opposite sex, but you haven't made that full transition, or you're not able to say out loud, I am gay, I'm lesbian, I'm transgender. Sometimes people are still working through those issues. So if you want to go ahead and see a therapist, to help you work through those and start talking about it. Do it now, not after your asylum case is decided, because the judge unfortunately cannot make a decision based on you might be gay. You have to kind of come to terms with those identities before your final asylum case hearing. How do you prove your nexus? Well, first is by proving your membership in whichever group it was. So, for example, if it is your political opinion that is at issue, show us the social media posts that you've been making expressing your political opinion. Show us letters or membership cards of what political group you belong with. Show us photos of you participating in protest. And that's not just in your home country, but also here in the United States. If there are groups that you can be involved with here in the US that advocate for that same position, then you can do that. I had an asylum case where the the final evidence where the government actually agreed without any questioning to allow the asylum case to be granted was because my client knew that the political leader of his organization was flying into Chicago for an event. And so he went to Chicago. He lives in Maryland. He went to Chicago to meet the leader of his political group from his home country and took a photo with him in the airport. When the government saw that photo of him with the political leader in the airport, they said, "We don't have any questions to ask him. We don't oppose his grant of asylum." Okay? So those things are you can use to establish your nexus. Also, letters from your friends, family, and neighbors can help to establish your nexus. I'm going to give you an example of that in a little bit. But mostly, if you don't have those things that you can rely on, your testimony is what is very important. And it's not just your testimony in court, but it's the consistency of your testimony. So from the very first time when you submit your asylum application, you want to establish your nexus and have it in there. When you give your detailed statement, establish your nexus to have it in there. When you go to court, establish, and they look at the consistency of your claims and each of those testimonies to judge how credible you are. So from the very first time you tell your story of your fear to return to the United States, it's important to consider and include all of these elements from the beginning so that the government attorney will not be able to say, it wasn't in your first filing, so why did you include it on your third or fourth filing? Okay. Let's see here. Since asylum is an international law, can the administration eliminate the asylum immigration pathway in the US? Okay, so asylum, there's only one portion of asylum that is international, and that is protection under the Convention Against Torture. The United States is in agreement with the United Nations that the government will not refuse entry to any person who has a credible fear of being harmed by their own government. Okay. All of the other asylum laws in the United States are created by the Immigration and Naturalization Act and are a product of US law. I would say, under normal circumstances, that we cannot refuse to be a part of the Convention Against Torture, but we are living in unprecedented times right now. So, unfortunately, I cannot give you a guarantee on that. I can't even guarantee that our Constitution is going to be intact by the end of the year. Evidence to establish future persecution. Now, the tricky thing about future persecution is that not only does it have to make sense to you, which is subjective, that it makes sense to you, it has to be an objective fear of future persecution that makes sense to somebody else. So sometimes I see claims where somebody has a fear of voodoo or something supernatural or something that's generally not accepted in all religions, some kind of religious conviction. Unfortunately, those are not considered to be objectively reasonable. The court might accept that they're subjectively reasonable, but they're not objectively reasonable. You have to be able to explain to someone else and have them understand how that future persecution might happen, and they accept it as well. You can do this by use of State Department reports, travel advisories, news articles, again, letters from friends and family. If you have letters from actual government officials saying it's not safe for this person to come back here, that's even better because that government official is saying, in my capacity with what I know about this government, this person cannot come here. If you've received any threats via Messenger, WhatsApp, etc., don't delete those before you screenshot them. Okay. A lot of times people will tell us that they've received threats, but I deleted them. I got a new phone number. Screenshot them first before you get rid of them because that will help you establish future persecution. Okay. And then the next one is internal relocation. So you have to prove that the harm that you would suffer is not specific to the one city that you were living in, but that it would occur no matter where you moved in that country. You can prove this by showing that you tried to relocate previously and you received continued threats or persecution. You can show this by showing that there's actually nowhere that you could move. And age does come into play with this. So, for example, when I have clients who are 14, 15, 16 years old, I can just tell the court the family house is only in Soyapango. Okay. This person is not of age where they would be able to find housing in any other part of El Salvador on their own. They have a lack of connections or housing in any other place. It would be unreasonable to require them to do so. Okay. Then you can also show some countries have checkpoints where either there's a gang that controls entry or exit into certain areas, or the militia controls entry and exit certain areas. So it's impossible to relocate to another area because of those checkpoints. You can also use country size as an argument. And you have to just not say, oh, my country's very small, but put it into terms that the government and the judge will understand. So if you say, um, my country is the size of Washington, D.C., as opposed to somebody relocating across the entire United States, that gives a visual of the difference, um, where somebody wouldn't be able to relocate safely because it's just not a big enough country. I think there was one question. Let's see. It wasn't okay. And then the last element is establishing that the government is unwilling or unable to assist you. You can do this by showing I tried to file a police report and they either refused to take the report or they refused to do any kind of investigation. Or you can show that the government has some policy that refuses to assist you. So, for example, if the government has a law that you will be arrested if you participate in any political activity that's against them, or a law that if you are not Muslim in the way that they define being Muslim, that the government may persecute you, that shows the government is unwilling or unable to assist you. Okay. What if the government administration persecuting you has changed? Okay, this does happen. So once you establish that you have been persecuted in the past and that it was because it's based on a nexus because, then it's the government's responsibility to show that the current government would not persecute you. So if you are still able to rebut their presumption, so if they present, oh, the government has currently changed, but if you can present evidence, but those people who previously harmed me are still there and they are being able to live with impunity, meaning they haven't been arrested or charged for their former crimes, then I still face fear. I still have fear of returning. Okay. So let's go through this sample letter. And in the sample letter that a friend is writing in support of another friend's asylum case, I want you to try and identify the elements that are being established by this letter. Where is the past persecution? Where's the future persecution? Where's the nexus? Where's the inability to internally relocate? And where's the government unable or unwilling? I'm going to read it out loud as well. My name is April Holloway, and I've been friends with XX since 2010. We lived in the same neighborhood during high school. I witnessed some of the threats that XX received because of her religious practices. On one occasion in May 2013, I saw her being harmed by several people while they yelled that she must convert or they would send her to hell. That meant that they would kill her. She was able to escape that incident, but I know that it is not safe for her to return here because people who practice this religion are commonly persecuted. The police will often overlook them being targeted for harm because the community at large does not agree with that religion. Since this is true across the country, I do not believe it would be safe for her to return and respectfully request that she be granted asylum. So let's start with the first one. Where does this letter help establish past persecution for the applicant? You can unmute yourself and tell me, or you can type it in the chat. Where is the past persecution being established in this support letter? You are the shyest group that ever attended a Nigerian Center event.
It says in the same neighborhood, so school or
So you're very close. So that does establish their relationship, but go down a little bit more. I witnessed some of the threats that XX received. So those threats constitute the past persecution that XX suffered. Yeah, very close. Also, this person goes on to say, I saw her being harmed by several people. So that's, being physically harmed, that's also past persecution. So this letter is establishing that past persecution occurred to this person. Okay. Thank you so much for volunteering, Monty. I appreciate it.
you're
All
welcome.
right. So let's see, Monty or Mr. Emmanuel or somebody else, tell me where you see the next element. Where is the future persecution? Where in this letter does this person indicate if XX is to return to this country, they will be harmed in the future?
Well, she said she was able to escape the incident, but that if she returns to the country, people who practice the same religion are, commonly persecuted. So that's
Exactly, Io, exactly. That part speaks directly to future persecution. If she escaped then, but if she was to return, she would be harmed again. Okay. Now let's go to nexus. Now, nexus in this case means that that past harm and that future harm is connected to a protected ground. Where does this letter help establish that the persecution was not random, it wasn't general, but it was protected to connected to a protected ground?
the aspect that says the police often overlook those being targeted for those. I
Because
mean,
they don't
being
agree with
targeted for the harm,
that.
yeah.
That part does help establish it. Also, in the beginning, I witnessed some of the threats that XX received because of her religious practices. So there are, those two parts do go to it's because of her religion, not because of general crime. Okay. And what you just talked about, Io, also hits on the government unable or unwilling, because here we have the police often overlook them being targeted, showing that the government is not really inclined to help these people, So she can't count on the protection of her government. XX can't account on the protection of her government if she returns here because the police just overlook this religion. The community at large doesn't agree with this religion, so she won't find protection here. Okay. And then the last thing that we haven't discussed is internal relocation. So, what in this letter helps establish that it would not be possible for XX to relocate to a different city, a different part of the country, and still practice her religion safely?
The aspect that says this is true across the country, that irrespective of where she goes to, across the country, she will still be targeted.
Exactly, IO, because this is true across the country. It would not be safe for her to return, right? Excellent. Good job. Thank you so much. So we're moving to a little bit of a different topic now. Um, this is something that you've seen in the news a lot lately. What is a credible fear interview? You may also hear the terminology reasonable fear interview. Um, these are interviews that are given to people when they first arrive in the United States. If they come seeking asylum specifically, they may have one of these interviews to determine whether or not they meet the very basic requirements to state a claim for asylum. And if they are not able to pass this interview, then they will be immediately deported. The difference between a credible fear interview and a reasonable fear interview is just the number of times you enter the United States. If it's your first time entering and seeking asylum, you go through a credible fear interview, which has a little bit lower burden. But if you've been in the United States previously, or you've attempted to enter the United States previously, you have a reasonable fear interview, which is a higher burden. Now, once you pass those, either one, credible fear or reasonable fear, it doesn't mean that you automatically are going to win your asylum case. It just means that you've stated sufficiently enough information that you probably would qualify, but does not guarantee that you're going to win. Also, it's not an application for asylum. So just having a CFI or an RFI does not mean that you have applied for asylum. It's just a step that they take sometimes at the border to go ahead and weed out people who are not meeting the basic requirements for asylum. All right, and by special request, some people wanted to know what protections are available for victims of domestic violence if you are undocumented. Well, there are a few different ones. The first one is a U visa. A U visa is only going to apply if criminal charges have been brought against the abuser. And you have to follow through with pressing that charge. So if you initially call the police, but you refuse to speak to the police when they arrive, or if you go to court and refuse to testify or refuse to go to court, then you would not be able to succeed with a U visa. You have to be willing to file the charges and follow the charges through to qualify for a U visa. The next one is VAWA. Oh, one more thing I want to mention about U visa. A lot of times people think that it only applies if it is domestic violence. It actually applies for other criminal activity as well. So if it's sexual assault or a felonious battery or kidnapping, those also qualify for U visa. It doesn't have to be just domestic violence. Okay. The next one is VAWA. If you were married to the person, whether you are a male or female, if you were married to the person who abused you and that person is a resident or a citizen, then you may be eligible for VAWA. If you are the child of a citizen or resident and that parent has been abusive to you, then you may also qualify for VAWA. And finally, if your child is a US citizen or resident and that child has been abusive to you, then you may qualify for VAWA, okay? This doesn't only include physical abuse. It can also include financial abuse, emotional abuse, and one thing people sometimes don't think of is also cultural abuse. So if you, for example, are a person who practices Christianity, you went into your marriage practicing Christianity, and you have been forced to practice a different faith, if you've been forced to cover your face and you didn't want to, or any of those things, that is cultural abuse. Also, the abuse is measured by the standards of the United States, not the standards of your home country. So if you come from a country where it was previously well within your right to for your spouse to hit you or otherwise push, shove, anything like that, it is not legal here in the United States, and that's the standard by which abuse is judged for VAWA, okay? The next option you might have for domestic violence is a T visa. So if there's an element of trafficking that was present, then you might be eligible for this. So for example, if you were forced to work without pay, if you were forced to provide sexual acts, those are elements of trafficking. Something that people don't think of is if you go out with your spouse for the day and your spouse is working and you're assisting them with working, whatever their job may be, restocking, or you're helping them drive from place to place, you're being forced to work. And if you're not being compensated for that work, there is an element of trafficking present. Another thing that people don't think about is children. Sometimes people bring children to the United States to serve as housekeepers for other families. And if that happened to you, that is trafficking. That's an element of trafficking that was present where you're now being forced to work in somebody else's home caring for their smaller children when you were also a child yourself. Okay? And the last option for undocumented victims of domestic abuse, if it occurred in your home country, you may be eligible for asylum. If it is common for women in your home country to be abused and the government refuses to take any action on this, then you may be granted asylum. It's a little bit harder now than it was in the past. There used to be an actual court case that said if you are forced to remain in a relationship where you're being abused, then that is an automatic qualifier for asylum. During Trump's first term in office, that case was overturned. And since that time, us attorneys have had to get creative on how we're going to get these domestic violence claims through. I have been successful by arguing that all women in a particular country constitute a protected group that qualifies for asylum. A lot of judges have accepted this argument, but only if we can show country conditions that support that. So for countries like Guinea, El Salvador, Congo, for countries where we've been able to show rampant abuse of women that is systemic and where the government does nothing to intervene, there are countries the U.S. government will accept that argument for. All right. And switching gears for the last time, our last topic is what to do if you are detained and what rights you have when you are detained. Disclaimer, once again, this is in flux because the standard that we had to use for these kind of situations is currently being challenged by the Trump administration. If you asked me in December 2024 what this process was, I would tell you with 100-degree certainty exactly how this goes down. But we've already seen incredible encroachments on this process. So I'm going to tell you what the process should be. And, unfortunately, I can't tell you that this is how it's going to be in the future. So the most important thing is what to do before you get detained. If you are currently undocumented, then you have to accept the fact that you might be detained and you have to take some proactive steps. If you have any legal process that's available for you to obtain residency, go ahead and start that process. Okay? If you don't have any process available, completely understand. But if you have some process available, go ahead and start that. Number 2, if you have children, you need to decide if you are detained and deported, do you want those children to remain in the United States or do you want them to go with you? Okay. If you want those children to remain in the United States, you need to prepare guardianship for them. Who is going to be responsible for taking care of those children and give them the legal power to do that? Otherwise, your children are going to go into foster care. And foster care may or may not be able to honor wishes of what family or fictive kin you want them placed with. Okay, so straighten that out yourself. If you want them to go with you, then you need to go ahead and put money aside for those children to be able to travel and make sure they have their passports up to date to be able to travel to follow you after you're deported. Okay. Put away money for legal assistance, childcare. So if you've started your legal process, but you're still undocumented, you don't have any paperwork yet, you've just started it, go ahead and put away money in the event that you are detained and now you need to pay for a bond or you need someone to care for your children while you're detained and fighting your immigration case. Go ahead and put that away. Number 4 is really, really important. Detail your immigration history. Go ahead and write an email to yourself or to a good friend detailing exactly what your immigration history is. When did you arrive in the United States? What have you applied for in the past? Do you have any criminal history? Because the most difficult thing is when you have a friend who comes to see me because they want to try and help you, But I ask them, okay, when did this person arrive? What kind of visa did they arrive on? And they can't tell me nothing. Okay. If that person's unable to give me your immigration history, it's very hard to figure out where do we go from here. So detail your immigration history and go ahead and provide that to a friend or two. And then all of your important documentation, your birth certificate, copy of your passport, your school certificates, receipts of anything that you have applied for, those things can go missing quickly. Okay, if there's a fire, if you get evicted from an apartment, they can get trashed, they can disappear very quickly. So scan all of those things, email them to yourself and to a friend. These are important things to do before you're ever detained, because it just makes it more difficult if you are detained and these things are not already taken care of. Now, if you are detained, what would normally happen is that you have two different hearings. The first is going to be a bond hearing to see if, while you're in immigration proceedings, will you remain detained or will you be released? During that bond hearing, they are going to evaluate if you are a danger to your community and if you are a flight risk. And depending on how they gauge those things, they will set a bond amount. You may be able to get out without paying any bond at all. In those situations where I've been able to get somebody released without paying anything, that person has a positive history of showing up in court when they're required to, a positive history of showing up for ICE appointments. That person has employment that they are showing up to, or if they're in school, we're able to get reports from their counselor, from their teachers of how they attend school on a regular basis, they participate in class, things like that. If you do have some minor criminal history, or if you have had a court case in the past where you didn't appear, but you appeared for one, didn't appear for the other, you might be assessed a bond of $5,000 to $10,000. If the criminal charges are serious, you might be denied bond altogether, and you have to remain detained throughout the entirety of your removal proceedings. The other hearing you have is the removal proceedings. During that time, you can submit any applications you're eligible for to remain in the United States. The most common application people submit is an asylum application, but you may also be eligible for cancellation of removal. You may also be eligible for residency if you already have an approved I-130. But at any rate, this is when you submit those applications that say you're eligible to remain in the United States, and then the judge will make a decision to grant or deny the application. If your application is denied, a removal order is issued. If you are detained, that means they're going to go ahead and physically remove you unless you appeal that decision. If you are not detained, they're going to leave it to you. It's your responsibility to either self-deport, or if you're detained at some point down the line, then you'll be physically removed. All right. Jamaica already spoke about the resources the Nigerian Center provides. One thing I do want to add is that we do have a YouTube channel where all of these seminars are recorded and posted. And so if you would like to see any of the older seminars for any information, we did one specifically about VAWA. We did one specifically about getting work authorization if you are a student. You can find those on the YouTube channel. All right, and I'm going to stop sharing. And if you have any questions, I see one question in the chat, but otherwise, if you have any questions, you can unmute yourself, or you can post this in the chat while I read this one. Does the court or USCIS consider the support letter of friends and family strong or credible? Yes. So if you have a letter from a friend or family member that is consistent with your own story, and where that person provides enough detail as to how they know that information, then it is considered credible, particularly if they're able to sign it and provide contact information or a copy of their own ID. So yes, those are considered strong and credible evidence, so long as they are consistent. Now, if somebody writes a letter that just says,